Hello, and welcome to the first episode of the Law Students Talk About Random Stuff podcast. Today, I have the pleasure of having a very special guest, Mr. Cameron Taylor, join me in the studio.
Thank you for having me. I'm very honored to be the very first guest brought onto the show.
Well, Mr. Taylor, you are the world-renowned expert on the Gladue Courts, and I could not think of anyone better to kick off the show with.
Please, just call me Cameron.
Well, Cameron, how did you get started with the Gladue Courts?
My first exposure to the Gladue Courts came while I was in law school. One of my law professors put a very large focus on Indigenous rights and customs, as well as laws surrounding Indigenous peoples. One of the Indigenous cases that we researched was the R.V. Gladue case.
For those viewers who might not be aware of the R.V. Gladue trial, what happened?
Jamie Tanis Gladue was an Indigenous woman living in British Columbia. On September 16, 1995, she had suspected that her boyfriend was cheating on her, and so she confronted him. In this confrontation, Gladue stabbed her boyfriend in the chest and was later charged with manslaughter and sentenced to 3 years imprisonment.
And what makes this case so significant that you were learning about it in law school?
Well, it's not actually the crime nor the charge that makes this case significant. Really, it was just an open-shut case. Instead, it was the sentencing and the challenge of Criminal Code Section 718.2e that makes this case interesting. Section 718.2e outlines that when a court is sentencing, they should take into consideration many different principles. Section E of this law states that all available sanctions other than imprisonment that are reasonable in the circumstances and consistent with the harm done to the victims or to the community should be considered for all offenders, with particular attention to the circumstances of Aboriginal offenders. To get away from this law jargon, what this actually means is that in certain circumstances, a punishment that is not prison could be used. An example of something like this would be community service to help mend community relations.
What happened in the sentencing trial?
In the sentencing trial, the judge took into account the absence of any serious criminal history, but did not take into account Gladue's traumatic history, including her mom dying at the age of 14. The judge also found that Section 718.2e did not apply to Indigenous people who were living off the reserve.
So, a woman charged with manslaughter and a misunderstanding of the criminal code? What happened next in the R.V. Gladue case?
The case was appealed to the British Court of Appeal, where the sentence was upheld. Then the case was brought to the Supreme Court of Canada. The ruling of the SEC was that the lower courts erred by having a very narrow approach to Section 718.2e. They strongly advised the lower courts of Canada to consider Indigenous offenders' backgrounds and make sentencing decisions accordingly. In terms of Gladue not being on reserve land, and therefore Section 718.2e did not apply, the court stated that Section 718.2e applies to all Aboriginal people wherever they reside, whether on or off reserve, in a large city or a rural area.
What were the reasons that the Supreme Court gave for this decision?
They did say that the lower courts had a very narrow view of the law, and this decision was made to address the severe problem of overrepresentation of Indigenous people in the criminal justice system. The thought behind it was that if the courts take extra consideration for the Indigenous peoples and punishments other than imprisonment, then it would solve the overrepresentation problem.
A very interesting case in Canadian history, and to think that it happened just over 20 years ago, finally wrapping up in 1999. Well, following the R.V. Gladue case, how did the Gladue Court start?
Well, following the case, the SEC thought it was important that steps were taken to further improve the overrepresentation issue, and so the Gladue Courts were created in 2001, named after the Gladue case, which was the first case to challenge Section 718.2e of the Criminal Code.
Have there been any other significant cases proving the overrepresentation issue of Aboriginals in our criminal justice system since the formation of the courts in 2001?
Certainly. Another key case would have been the R.V. Ipili case, which concluded in the year of 2012. This case seemed to reiterate the key ideas which were brought forward in the Gladue case, and specifically highlighted that the sentencing processes for Aboriginal people needed to be done in a different perspective.
What exactly was the issue within this case?
The main issue in this appeal was how to determine a just and proper sentence for Aboriginal offenders for a breach of long-term supervision orders.
What specific factors did the courts feel must be considered when sentencing the offender?
The courts emphasized that historical factors of cultural appropriation, poverty, and the history of abuse in residential schools should be considered.
Well, now getting back on the topic of Gladue courts, what is it that the courts do?
The courts hear cases in which an Indigenous person has been charged with a criminal offense. Then, if found guilty, sentences are made in line with Indigenous traditions, such as community justice programs, to make amends for the crime. As specifically said in the conclusion of the R.V. Gladue case, the factors which must be attributed and examined when looking into the sentencing of Aboriginal people are A. The unique systemic or background factors which have played a part in bringing this particular Aboriginal offender before the courts, and B. The types of sentencing procedures and sanctions which may be appropriate in the circumstance for the offender because of his or her particular Aboriginal heritage or connection.
Along with the courts, I have heard of Gladue reports. Would you mind expanding on what these are?
Of course, Gladue reports are a special type of pre-sentencing and/or bail hearing report which may be requested by a Canadian court.
In what circumstances would this type of report be necessary?
Well, when considering sentencing an Aboriginal offender, this report is used to help understand and account for the circumstances faced by the Aboriginal people in their daily life.
What would a Gladue report generally include?
Well, that's a very good question. A Gladue report generally includes 4 major topics. The personal history of the accused could possibly include childhood and family environment as well as trauma experienced in the daily life or in the past. It could also include the history and current context of the community and the accused relationship to the community. 3. The accused's previous appearances in court, if any, as well as their reactions to the crime committed. And 4. A summary of the individual and systemic factors to be taken into consideration.
Very interesting. But what would you say is the main difference between a Gladue report and a pre-sentence report?
Both are seen to be quite similar. However, a Gladue report focuses mainly on the systemic and historical factors affecting Aboriginal offenders and their communities. A Gladue report may be submitted to any Gladue court or any other outstanding Canadian courts who may request the document.
On that note, when were the Gladue courts first opened to the public?
The first Gladue courts opened in 2001, and now there are over 20 Indigenous-focused courts all across Canada, and even more that have adopted the Gladue court system.
I also understand that the judges of these Gladue courts need to go through some specialized training. Is that correct?
Yes, due to the fact that these courts operate slightly differently than the average criminal court, the judges have to get trained to learn some of the different sentencing options that are available.
There is also some controversy concerning this extra training, right?
Yes, in a study done by Paula Morato and Kelly Hannah Moffat, who are professors of law at the University of Toronto, it was found that there was not sufficient training among both lawyers and judges in the court cases that they observed. This lack of training or sufficient knowledge can lead to mistakes and misinterpretations of the law, which are never a good thing.
Are measures being put in place to solve this issue?
Yes and no. More standardized training is necessary for these courts to keep operating. On the federal level, some attempts to set up this training have been made, but nothing has been made permanent yet. In my opinion, most of the training should go towards helping judges understand Section 718.2e of the Criminal Code, and also towards a more guided sentencing system, as opposed to whatever the judge deems reasonable.
Now, I would like to just quickly jump back to something that was mentioned earlier in the interview. The overrepresentation of Indigenous people in the criminal justice system within Canada.
Of course, as I said before, this is one of the primary reasons for the creation of the Gladue courts, and is still a very prevalent issue today. By the courts mandating punishments other than prison, when reasonable, the goal is to keep more Indigenous people out of jail. One stat that was floating around a few years ago was that Indigenous people make up only 5% of the Canadian population, yet they make up 27% of the prison population. This overrepresentation is truly an important issue concerning Indigenous people in Canada, and the focus on Section 718.2e in the Gladue Courts are a good starting point, but I believe more has to be done to truly solve this issue.
Overall, what would you say is the main objective of the Gladue Principles?
The main objective is to require Canadian courts to take in all reasonable alternatives to incarceration, paying particular attention to Aboriginal offenders within criminal sentencing.
Well, Mr. Taylor, it has been an absolute pleasure having you here on our show today. From all of us here, we extend a huge thank you for your time.